Hi everyone, my name is Haroop Aldukian. I'm a practicing bankruptcy attorney here in the state of California. And in this video, I wanted to break down exactly what happens when you file for a Chapter 7 bankruptcy. What's the timeline look like? I have to break it down into 4 steps. You have the pre-filing, game planning stage, you have the post-filing stage, you have the hearing, and then you have your discharge. So what happens in the pre-filing game plan stage? A lot of times when I meet my clients, we come up with a game plan. And that game plan basically is, okay, when can the fees be paid in full? When can documents come in on time? That way we can prepare everything on a timely basis. Usually in the bankruptcy paperwork, you're doing an analysis for income up to 6 months prior to filing. So I want to make sure I have updated paperwork. We want to make sure we have the correct tax returns. We have bank statements. Everything is up to the petition date, the filing date. During the pre-filing game plan stage, a lot of our clients have to complete what's called credit counseling course. It is a budgeting course. This is the pre-filing course that's required for everyone to complete prior to filing for bankruptcy protection. The credit counseling course is something that can be done online. Once you complete that credit counseling course, a certificate is issued. A certificate is usually forwarded to your attorney, or it's emailed to you. You can send it off to your attorney. That certificate is needed and is mandatory to be part of your bankruptcy paperwork when you file. Some of the other documents that need to be provided to the attorney, that way it's a part of your bankruptcy filing, is usually pay stubs 60 days prior to filing. Most attorneys will ask you for a full 6 months prior to filing so they can complete that means test analysis. That's the analysis to show that you qualify for the Chapter 7 bankruptcy, but ultimately 60 days prior are also being submitted so the trustee in your case, the Chapter 7 trustee, can review that paperwork to make sure numbers make sense as far as what you've presented in your budget. One of the main parts too of the pre-filing course is you want to have a signed set of documents. A lot of times everything is filed electronically in the bankruptcy system, but you do have to sign your full set of bankruptcy documents, the voluntary petitions, schedules, and statements. The documents can be anywhere from 50 to 75 pages long. The signatures range from anywhere from 10 to 11 signatures on the document. Those have to be holographic, meaning that it has to be a wet signature. A lot of times an attorney might have you come into their office, have you review the paperwork, or email you the documents for you to print out, read through. You want to make sure you read thoroughly, make sure all assets are listed correctly, your income makes sense, the statements make sense, everything is true and accurate. You always want to make sure your social security number is correct on there, your mailing address is correct so the court can send you your notices timely, and you want to also make sure your creditors are all listed. If you need to file any sort of amendments to add creditors later on, there could be an additional fee for that. There is definitely a court filing fee, an additional filing fee for that. Your attorney might charge you an additional fee as well. So you always want to make sure that you build that master filing list or master creditor list. Here at my office, I pull a multi-bureau credit report for you. I build your master creditor list with you. I give you a copy of it so we both have a list. That way we know exactly what is and is not on there. Ultimately, you're going to be kind of the front lines on that. If there's any letters or notices that you're receiving, you want to make sure that you give them to your attorney so everything is on that master list that you create. Next, we have the post-filing. Post-filing stage is when your case has been filed, you now have a case number. So what does that mean? When you have a case number, your case is assigned to a Chapter 7 trustee. Usually the Chapter 7 trustee is another bankruptcy attorney or an accountant that's assigned to overlook your case or to review your case. A trustee is usually a contractor that is contracted from the Department of Justice under the umbrella of the Department of Justice through the United States Trustee's Office. Their main job is to see if there are any assets in your case, if there's any exposure in your case, meaning that if there's anything that can be sold to pay off your creditors. The best way to think about it is they're kind of like the referee. They're the referee in your case. They're not your attorney. They're not the creditor's attorney. They're looking to see if income makes sense, assets are properly disclosed, and if there's any exposure in any of those assets so they can sell that asset or pull money from that asset in order to pay off your creditors. You're assigned that hearing date and time. That hearing date and time is the 341A meeting of creditors. It's called 341A because of the code section of the bankruptcy code. It's called a meeting of creditors because it's the opportunity for creditors to come and ask you questions about your assets But 9 out of 10 times, creditors don't really show up to this type of thing. You have regular debt in that you have regular consumer debt, you have regular credit cards, personal loans, you had some payday loans, even old utility bills. Those creditors are not going to show up. If you incurred any of this debt by fraud, misrepresentation, and the creditor knows it or feels like you did, they may show up. Misrepresentation, and the creditor knows it or feels like you did, they may show up. Some of these people might show up if you've had a judgment against you for debt that you owed that was because of fraud or misrepresentation as a judgment against you. That type of creditor will likely show up at the 341A. A lot of times if there's any issues with your account or if there's been any recent usage, they'll reach out to your attorney ahead of time. You might be able to work something out. But your 341A hearing that is scheduled about a month after your case is filed, it's going to be primarily you, your attorney, and the trustee. Since the COVID-19 pandemic, a lot of these hearings have been conducted by telephone and by Zoom. So you're not even having to drive down to the court anymore, which is really nice. You can do it from the convenience of your home by calling either the conference number you're provided or the Zoom meeting ID that you're provided from the trustee. Some trustees will file an official notice in your case to let you know that your hearing is going to be done either by telephone and by Zoom. And once your case is filed, every trustee will have their own set of documents that they'll request from you. By the bankruptcy code, you have to provide your most recently filed tax return to the trustee. Depending on when last time it is you filed, you have to provide your most recently filed tax return. If you are on Social Security income or you're unemployed and you haven't filed a tax return in a number of years, there is a tax return declaration that can be signed. Your attorney could either draft one for you or the trustee will provide one for you to sign, saying that you haven't filed a tax return recently, so therefore you don't have one to turn over. You also need to provide your ID and your social to the trustee. Your hearing will not be heard. Your hearing will not move forward unless those two items are properly sent over to the trustee. Some trustees will ask for additional documentation like your bank statements. A lot of times you're providing 3 months prior to filing, including the petition date. So you want to make sure your bank statements cover the date that you filed and the number in your bank account matches what's in your schedule so it can be protected. What they're trying to do here is they're just making sure that you didn't transfer large sums of money out of your account. Things make sense. They're usually looking for transactions that are over $500, who would send it to, why you sent it to somebody, paying things like rent or utilities or a cell phone bill. They can tell when things like that. But if you're sending $1,000 a month to somebody and it's not disclosed anywhere in your paperwork or it's not explained, you're gonna have to be ready to answer as to why you're sending money where you're sending it, and the trustee may or may not take issue with that, and that's something you want to discuss with your attorney. Part of the post-filing section is you want to also make sure you file your certificate of financial management or the financial management course or post-filing course, second course. It's called a number of different things, but usually the company that you use to do your credit counseling course will also offer the course in financial management. The financial management course is kind of like traffic school for bankruptcy. It's about 30 pages that you're reading, and at the end there's a 20-question quiz where you need to score a passing score in order to be issued a certificate. That certificate needs to be filed with the court before your case is discharged or closed. You actually won't get your discharge until you have your financial management course set. That's something that usually gets done between filing and your hearing. A lot of the times I have my clients do it before their hearing. That way they have one less thing to worry about once their hearing is completed, but the trustee will remind you at the hearing to get the financial management course completed. The discharge order is entered at the end of the 60-day period after your 341A hearing, meaning that once your hearing is completed and no other information is requested from you, the discharge will automatically be entered by the court. This is why you want to complete that financial management course. Once you complete that financial management course and you don't have any additional filings or amendments or anything that is requested of you from the trustee, the discharge will automatically be entered and a copy will be mailed to you and to all your creditors. Once the discharge order is entered, that is the piece of paper that says that you are officially debt-free. That is when you have that official fresh start that you were we're looking for. You want to keep a copy of that discharge order for your records, because there is going to be an opportunity for creditors to ask for that if you apply for credit cards, loans, or try to refinance your car, what have you. Anytime you're dealing with trying to obtain credit, your credit report is going to show a bankruptcy filing, and they're going to ask you for a copy of that credit report. So here in my office, what I do is I usually electronically send one over. I email the copy of the discharge order over, so you can always have a copy in your email. You can save it to your computer or your phone. That way in the future, it's handy and ready to go. You'll also have a copy mailed to you to the mailing address that is on your paperwork. So you always want to make sure that your address is up to date in your paperwork. That way, any important notices from the court get mailed to you directly, and you can keep them for your records.